हेलो फ्रेंड्स एंड वेलकम टू आवर टेक्साज यूट्यूब चैनल, जहां पे हम आपसे सभी तरह की लीगल, टैक्सेशन और फाइनेंशियल मैटर्स पे नए नए वीडियोस शेयर करते रहते हैं। अभी लीगल स्टडीज़ का चल रहा है, तो इसमें आज हम आपसे बात करेंगे अबाउट फॉरेन जजमेंट्स। फॉरेन जजमेंट दो अलग अलग सेक्शंस को, इनफैक्ट दो अलग अलग लॉ को एंटेल करता है। अभी हम जो पढ़ रहे हैं वो एज पर द परव्यू ऑफ सीपीसी पढ़ रहे हैं, लेकिन ये सेम चीज़ आपने पढ़ा होगा आर्बिट्रेशन के मैटर में भी। इनफैक्ट अगर मैं ये कहूँ तो फॉरेन जजमेंट्स का पूरा कॉन्सेप्ट आर्बिट्रेशन एंड कॉन्सिलिएशन एक्ट 1996 में दिया हुआ है। सीपीसी में उसके कुछ परव्यू को कर्टेल या एंटेल करने के लिए इसका जिक्र कर रहे हैं हम आज। तो आइए चलते हैं टॉपिक्स पे। और आपको पता ही है, राइटिंग पॉइंट ऑफ व्यू से मैं बताता हूँ सो दैट यू कैन हैव अ गुड मार्क्स इन एग्जाम्स। और कॉन्सेप्ट वाइज भी अगर आपके पास पॉइंट टू पॉइंट रहेगा तो यू आर इन अ बेटर पोजिशन ऑफ डिबेट एंड टॉक। एंड इट्स ऑल अबाउट डिबेटिंग, राइट, द प्रोफेशन विच वी आर इन। तो क्वेश्चन आपके सामने कैसे आएंगे? व्हाट डू यू मीन बाय फॉरेन जजमेंट? एक्सप्लेन इट्स नेचर, स्कोप एंड ऑब्जेक्ट। आर द फॉरेन जजमेंट्स conclusive, binding on the parties? When are the binding and when are they are not binding on the parties in India? आगे बढ़ते हैं विथ डेफिनेशन। पहले इसकी मीनिंग को देखते हैं। फॉरेन जजमेंट मीन्स अ जजमेंट ऑफ अ फॉरेन कोर्ट, एंड फॉरेन कोर्ट मीन्स अ कोर्ट सिचुएटेड आउटसाइड इंडिया। अब फॉरेन वर्ड से ही ये सारी चीज़ें क्लियर हो जाती हैं, फिर भी आपके समझ के लिए फॉरेन जजमेंट मीन्स अ जजमेंट ऑफ अ फॉरेन कोर्ट। फॉरेन कोर्ट मतलब वो कोर्ट जो फॉरेन में है। फॉरेन मतलब अब्रॉड, अब्रॉड मतलब बाहर। एंड फॉरेन कोर्ट्स मीन्स अ कोर्ट सिचुएटेड आउटसाइड इंडिया सिंपली, एंड नॉट स्टैब्लिश्ड और कॉन्स्टिट्यूटेड बाय द अथॉरिटी ऑफ द सेंट्रल गवर्नमेंट। अब जाहिर सी बात है, कोई कोर्ट अगर लंदन में बना हुआ है तो वो लंदन के लॉ से डिफाइन होगी, लंदन के लॉ से गवर्न होगी, वहाँ के रूल्स माने जाएंगे। वहाँ पे हमारा आईपीसी सीपीसी थोड़ी चलेगा। यह अलग बात है कि हमारा आईपीसी सीपीसी वहीं से आया है। दस अ फॉरेन जजमेंट मीन्स एडजुडिकेशन बाय अ फॉरेन कोर्ट अपॉन अ मैटर बिफोर इट। Nature and scope of foreign judgment. Section 13 contains the principle of res judicata in foreign judgment. This provision embodies the principle of private international law that a judgment derived by a foreign court of competent jurisdiction can be enforced in India. The section is not confined in its application to plaintiff. A defendant is equally entitled to non-suit the plaintiff on the basis of a foreign judgment. मतलब वैसे वर्षा भी ये काम करेगा। Objects of foreign judgment. The judgment of a foreign court is enforced on the principle that where a court of competent jurisdiction has adjudication upon a claim, a legal obligation arises to satisfy that claim. The rule of private international law of each state must in the very nature of things differ, but they by committee of nations certain rules are recognized as common to civilized jurisdiction. जब आर्बिट्रेशन का भी कॉन्सेप्ट हमने पढ़ा था तो हमने देखा था कि लॉज मैक्सिमम जो बने हैं इंटरनेशनल ट्रेड के अनसेट्राल के प्लेटफॉर्म पे, अनसेट्राल आपको याद ही होगा, थ्रू पार्ट ऑफ द जुडिशियल सिस्टम ऑफ ईच स्टेट दिस कॉमन रूल्स हैव बीन अडॉप्टेड टू एडजुडिकेट अपॉन डिस्प्यूट्स इन्वॉल्विंग अ फॉरेन एलिमेंट एंड टू effectuate judgments of foreign court in certain matters. Or as a result of the international conventions, such recognition is accorded not as an act of courtesy but on consideration of justice, equity, and good conscience. For example, A sues B in a foreign court. The suit is dismissed. The judgment will operate as a bar to a fresh suit by A against B in India on the same cause of action. तो यहाँ पे पूरी तरह से रेस जुडिकाटा अप्लाई होता है। A sues B in a foreign court, the suit is decreed. A then sues B on that judgment in India. A will be precluded from putting in issue the matter which were directly and substantially in issue before the foreign court and adjudicated upon by the court. ये भी रेस जुडिकाटा के तहत अप्लाई होगा। कंक्लूसिव नेचर ऑफ फॉरेन जजमेंट। तो इसका बाइंडिंग नेचर जो होता है उस पर हम टॉपिक पे बात करते हैं। अकॉर्डिंग टू सेक्शन 13, a foreign judgment is conclusive and will operate as res judicata between the parties thereto, except in the cases mentioned therein. Dice is of the opinion that a foreign judgment is conclusive as to a matter thereby adjudicated upon and cannot be impeached for error either of fact or of law. और एक तीसरा चीज भी होना चाहिए था, और of fact and law. Circumstances in which foreign judgments are not binding. Section 13 provides following 6 circumstances in which foreign judgment will not be conclusive. ये सारे बेसिक जजमेंट्स हैं जो कॉमन कंसाइन से ही निकलते हैं. Foreign judgment by a competent, not by a competent court. Foreign judgment not on merits. Foreign judgment against international or Indian law. Foreign judgment opposed to natural justice. Foreign judgment obtained by fraud. Foreign judgment founder on breach of Indian law. These are the same common constraints topic जिसपे ऑफ कोर्स सी बात है कि वो डिबार ही होगा. अब देखते हैं पहला पॉइंट, फॉरेन जजमेंट नॉट बाय कॉम्पिटेंट कोर्ट. It is fundamental principle of law that the judgment or order passed by observance of the court which has no jurisdiction is null and void. Thus, the judgment of a foreign court to be conclusive between the parties must be of judgment pronounced by the court of competent jurisdiction. Such judgment must be by a court competent both by the law of the state which has constituted it, and in an international sense, it must have directly adjudicated upon the matter which is pleaded as res judicata. But what is conclusive is the judgment that is the final adjudication as not the reason for the judgment given by the foreign court. Thus, if A sues B in a foreign court and if the suit is dismissed, the decision will operate as a bar to a fresh suit by A in India on the same cause of action. On the other hand, if a decree is passed in favor of A by a foreign court against B and he sues B on the judgment in India, B will be precluded from putting an issue in the same matter that were directly and substantially in issue in the suits. Foreign judgment not on merits. In order to operate as res judicata, a foreign judgment must have been given on the merits of deciding the case. A judgment is said to have been given on merits when, after taking evidence and after applying his mind regarding the truth, justice, or falsity of the plaintiff's case, the judge decides the case one way or the other. Thus, when the suit is dismissed for default of appearance, judge of the plaintiff, or of non-production of the document by the plaintiff, even before the written statement was filed by the defendant, or whether the decree was passed in consequence of the default of defendant in furnishing security or after refusing leave to, such judgments are not on merits. Foreign judgment against international or Indian law. A judgment based upon an incorrect view of international law or of refusal to recognize the law of India where such law is applicable is not conclusive. But the mistake must be apparent on the face of the proceeding. Thus, wherein suit instituted in England on the basis of a contract made in India, the English court erroneously applied English law. The judgment of the court is covered by this clause, inasmuch as it is general principle of private international law that the rights and liabilities of the parties to a contract are governed by the place where the contract is made. लेक्स लोकी का जो प्रिंसिपल है, foreign judgment opposed to natural justice. It is the essence of a judgment of a court that is, it must be obtained after due observance of the judicial process. That is, the court rendering the judgment must observe the minimum requirements of natural justice. It must be composed of impartial persons, act fairly without lass and in good faith. It must give reasonable notice to the parties to the dispute and afford each party adequate opportunity of presenting his case. यहाँ पे P. A judgment is the result of bias or want of impartiality on the part of a judge will be regarded as nullity. उसकी कोई वैल्यू नहीं होगी. And the trial quorum non judice, मतलब हुआ ही नहीं, हम ऐसा मानेंगे. But the expression natural justice in clause D of section 13 relates to the irregularities in procedure rather than to the merits of the case. A foreign judgment of a competent court, therefore, is, even if it is proceeds on an erroneous view of the evidence of the law, if the minimum requirement of the judicial proceeding are assured, correctness of the judgment in law or of evidence is not predicated as a condition for recognition of its conclusiveness by the municipal court. Thus, a foreign judgment is not open to attack on the grounds that the law of domicile had not been properly applied in deciding the validity of the adoption of that court disagrees with the conclusion of the foreign court. If otherwise, the principle of natural justice have been complied with. Foreign judgment obtained by fraud, obvious सी बात है ये तो. It is a well established principle of private international law that if a foreign judgment is obtained by fraud, it will not operate as res judicata. The fraud may be either fraud on the part of the party invalidating a foreign judgment in whose favor the judgment is given, or fraud on the court pronouncing the judgment. Such fraud, however, should not be merely constructive but must be actual fraud consisting of representation designed and intended to mislead. Mere concealment of the fact is not sufficient to avoid a foreign judgment. Foreign judgment founded on breach of Indian law. Where a foreign judgment is founded on the breach of an Indian law enforced in India, it would not be enforced in India. The rules of private international law cannot be adopted mechanically and blindly. Every case which comes before an Indian court must be decided in accordance with the Indian law. It is implicit that foreign law must not offend our public policy. Thus, a foreign judgment for a gaming debt or a claim which is barred under the law of limitation in India is not conclusive. Similarly, a decree for divorce passed by a foreign court cannot be confirmed by an Indian court if under the Indian law the marriage is indissoluble. Conclusion देखते हैं. A foreign judgment is conclusive and will operate as res judicata between the parties and their privies, not strangers. It is firmly established that the foreign judgment can be examined from the point of view of competence, not of errors. I consider whether a judgment of a foreign court is conclusive. The court in India will not require whether conclusions recorded by a foreign court are correct or findings other tenable. In other words, the court cannot go into the merits of the original claim, and it shall be conclusive as to a matter thereby directly adjudicated upon between the same parties, subject to the exceptions enumerated in clause A to 1 of section 13. तो ये था हमारा फॉरेन जजमेंट का टॉपिक. आपको अगर ये नोट्स चाहिए पीडीएफ में तो यू जस्ट हैव टू कमेंट बिलो द वीडियो एंड राइट योर नेम. अगर आप स्टूडेंट हैं तो कॉलेज नेम, एंड इफ़ यू आर प्रोफेशनल देन जस्ट राइट जॉब एंड योर ईमेल एड्रेस. वी विल मेल यू द PDF copy ASAP. So thank you. I hope you like the video. अगर आपको ये वीडियो पसंद आया है तो उसे लाइक करें, शेयर करें, कमेंट करें, और हमारे चैनल को अगर अभी तक सब्सक्राइब नहीं किया है तो इस तरह की और भी वीडियोस के लिए सब्सक्राइब ज़रूर कर लें. और अगर आपको लगता है आपकी फ्रेंड किसी भी फ्रेंड को ये चाहिए तो प्लीज़ शेयर द वीडियो विद देम. थैंक यू.